Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Ladies and gentlemen, the bailiff is going to give each of you a copy of the final jury instructions for the penalty phase. Again, this is your copy. Feel free to make any notes you would like on your copy. Your copy will be shredded at the end of the trial. I am going to read these instructions to you. I invite you to read along with me, beginning on page 2. Members of the jury, at this phase of the sentencing hearing, you will determine whether the defendant will be sentenced to life imprisonment or death. The law that applies is stated in these instructions, and it is your duty to follow all of them whether you agree with them or not. You must not single out certain instructions and disregard others. You must not be influenced at any point in these proceedings by conjecture, passion, prejudice, public opinion, or public feeling. You are not to be swayed by mere sympathy not related to the evidence presented during the penalty phase. You must not be influenced by your personal feelings of bias or prejudice for or against the defendant or any person involved in this case on the basis of anyone's race, color, religion, national ancestry, gender, or sexual orientation. Both the state and the defendant have a right to expect that you will consider all the evidence, follow the law, exercise your discretion conscientiously, and reach a just verdict. I do not mean to indicate any opinion on the evidence or what your verdict should be by any ruling or remark that I have made or may make during this penalty phase. I am not allowed to express my feelings in this case, and if I have shown any, you must disregard them. You and you alone are the triers of fact. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a just verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and change your opinion if you become convinced that it is wrong. However, you should not change your honest belief concerning the weight or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. You are to apply the law to the evidence and this way decide whether the defendant will be sentenced to life imprisonment or death. The evidence you shall consider consists of the testimony and exhibits the court admitted in evidence during all of the 3 phases of this trial. It is the duty of the court to rule on the admissibility of evidence. You shall not concern yourselves with the reasons for these rulings. You shall disregard questions and exhibits that were withdrawn or to which objections were sustained. Evidence that was admitted for a limited purpose shall not be considered for any other purpose. You shall disregard testimony and exhibits that the court has not admitted or the court has stricken. The lawyers may stipulate certain facts exist. This means both sides agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. You are to treat a stipulation as any other evidence. You are free to accept it or reject it, in whole or in part, just as any other evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise observed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. During the aggravation phase of the trial, you found that the state had proved that a statutory aggravating circumstance exists, making the defendant eligible for the death sentence. During this penalty phase, the defendant and the state may present any evidence that is relevant to the determination of whether there is mitigation that is sufficiently substantial to call for a sentence less than death. The state may also present any evidence that demonstrates that the defendant should not be shown leniency. Leniency means a sentence less than death. Mitigating circumstances may be found from any evidence presented during any of the phases of the trial. You should consider all of the evidence without regard to which party presented it. Each party is entitled to consideration of the evidence, whether produced by that party or by another party. You are the sole judges of the credibility of the witnesses and what weight is to be given the testimony of each witness. In considering the testimony of each witness, you may take into account the opportunity and ability of the witness to observe, the witness's memory and manner while testifying, any interest, bias, or prejudice the witness may have, the reasonableness of the testimony of the witness considered in light of all the evidence, and any other factors that bear on credibility and weight. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. The attorney's remarks, statements, and arguments are not evidence, but are intended to help you understand the evidence and apply the law. The attorneys are entitled to make any objections that they deem appropriate. These objections should not influence you, and you should make no assumptions because of objections by the attorneys. Relatives of the victims made statements relating to personal characteristics and uniqueness of the victims and impact of the murder on the victim's family. You may consider this information to the extent that it rebuts mitigation. You may not consider the information as a new aggravating circumstance. Mitigating circumstances are any factors that are a basis for a life sentence instead of a death sentence, so long as they relate to any sympathetic or other aspect of the defendant's character, propensity, history or record, or circumstances of the offense. Mitigating circumstances are not an excuse or justification for the offense, but are factors that in fairness or mercy may reduce the defendant's moral culpability. Mitigating circumstances may be offered by the defendant or state or be apparent from the evidence presented at any phase of these proceedings. You are not required to find that there is a connection between a mitigating circumstance and the crime committed in order to consider the mitigation evidence. Any connection or lack of connection may impact the quality and strength of the mitigation evidence. You must disregard any jury instruction given to you at any other phase of the trial that conflicts with this principle. The fact that the defendant has been convicted of first-degree murder is unrelated to the existence of mitigating circumstances. You must give independent consideration to all of the evidence concerning mitigating circumstances despite the conviction. The circumstances proposed as mitigation by the defendant for your consideration in this case are: 1. Defendant was 27 years old at the time of the offense. 2. Defendant has no prior criminal history. 3. Defendant was a good friend. 4. Defendant lacked support from her family. 5. Defendant suffered abuse and neglect as a child and as an adult. 6. Defendant tried to make the best of her life. 7. Defendant consistently tried to improve herself. 8. Defendant is a talented artist. You are not limited to these proposed mitigating circumstances in considering the appropriate sentence. You also may consider anything related to the defendant's character, propensity, history or record, or circumstances of the offense. The defendant is not required to testify or make any statement, and you are precluded from drawing an inference against her should she decide not to testify or make a statement. The decision on whether or not to testify or make a statement is left to the defendant, acting with the advice of her attorneys. You must not let this choice affect your deliberations in any way. The state may submit evidence to rebut mitigation evidence. You may individually consider rebuttal evidence in determining the existence of a mitigating circumstance or in assessing the significance of that mitigating evidence. You shall not consider rebuttal evidence as aggravation. You must decide the appropriate sentence based on the facts of the case and by applying these jury instructions. You must not consider the financial cost of any possible punishment when deciding whether to sentence the defendant to life in prison or death. While all 12 of you had to unanimously agree that the state proved beyond a reasonable doubt the existence of a statutory aggravating circumstance, you do not need to unanimously agree on a particular mitigating circumstance. Each one of you must decide individually whether any mitigating circumstance exists. You are not limited to the mitigating circumstances offered by the defendant. You must also consider any other information that you find is relevant in determining whether to impose a life sentence, so long as it relates to an aspect of the defendant's background, character, propensities, record, or circumstances of the offense. The defendant bears a burden of proving the existence of any mitigating circumstance that the defendant offers by a preponderance of the evidence. That is, although the defendant need not prove its existence beyond a reasonable doubt, the defendant must convince you by the evidence presented that it is more probably true than not true that such a mitigating circumstance exists. In proving a mitigating circumstance, the defendant may rely on any evidence already presented and is not required to present additional evidence. You individually determine whether mitigation exists. In light of the aggravating circumstances you have found, you must then individually determine if the total of the mitigation is sufficiently substantial to call for leniency. Sufficiently substantial to call for leniency means that mitigation must be of such quality or value that it is adequate, in the opinion of an individual juror, to persuade that juror to vote for a sentence of life in prison. Even if a juror believes that the aggravating and mitigating circumstances are of the same quality or value, that juror is not required to vote for a sentence of death and may instead vote for a sentence of life in prison. A juror may find mitigation and impose a life sentence even if the defendant does not present any mitigation evidence. A mitigating factor that motivates one juror to vote for a sentence of life in prison may be evaluated by another juror as not having been proved, or if proved, as not significant to the assessment of the appropriate penalty. In other words, each of you must determine whether, in your individual assessment, the mitigation is of such quality or value that it warrants leniency in this case. The law does not presume what is the appropriate sentence. The defendant does not have the burden of proving that life is the appropriate sentence. The state does not have the burden of proving that death is the appropriate sentence. It is for you, as jurors, to decide what you individually believe is the appropriate sentence. In reaching a reasoned moral judgment about which sentence is justified and appropriate, you must decide how compelling or persuasive the totality of the mitigating factors is when compared against the totality of the aggravating factors and the facts and circumstances of the case. This assessment is not a mathematical one, but instead must be made in light of each juror's individual, qualitative evaluation of the facts of the case, the severity of the aggravating factor, and the quality of the mitigating factors found by each juror. If you unanimously agree there is mitigation sufficiently substantial to call for leniency, then you shall return a verdict of life. If you unanimously agree there is no mitigation, or the mitigation is not sufficiently substantial to call for leniency, then you shall return a verdict of death. Your decision is not a recommendation. Your decision is binding. If you unanimously find that the defendant should be sentenced to life imprisonment, your foreperson shall sign the verdict form indicating your decision. If you unanimously find that the defendant should be sentenced to death, your foreperson shall sign the verdict form indicating your decision. If you cannot unanimously agree on the appropriate sentence, your foreperson shall tell the judge. I will read the rest of the instructions to you after the attorneys have completed their arguments. Because of the hour, we are going to take an early lunch recess. I'm going to ask that you all return at 1:15. Please remember the admonition. You are excused.
Please stand for the jury.
The record will show the jury has left the courtroom. Counsel, is there anything else before the recess?
No, thank you.
No, Your Honor.
We are at recess.